morning again. I hope you had a rewarding time yesterday. For those that were able to attend the two sessions yesterday, today we will be having another two sessions, starting with understanding international arbitration. And we have the pleasure of an excellent speaker, and one of the is arbitrator that we have from Ghana to take us through the journey of arbitration this morning. Her name is Nania Owusu-Ankomah. She's a litigation and arbitration practitioner and a partner at Owusu-Ankomah, a first-tier law firm in Ghana. She regularly advises and represents clients in a range of high-value litigation and arbitration disputes, including construction disputes, and is particularly noted for her innovative approach to solving complex legal issues. Naya sits as an arbitrator and has served as a member of the Electronic Communications Tribunal of Ghana, a quasi-judicial body with a three-member panel that hears appeals in respect of the regulation and licensing of telecommunications companies, televisions and radio stations, and internet service providers in Ghana. Naya is dual qualified, called to the bar in England and Wales and in Ghana. She has a first-class bachelor's degree in political science and philosophy from the University of Ghana. She has an LLM and qualifying law degree from the University of Leeds, where she won the Ford and Warren Prize as the most meritorious LLM student. Naya also is an alumna of the International Lawyers for Africa flagship program, through which she undertook a 3-month secondment program with the International Arbitration Practice at Ogan Lovels in London. Naya, thank you for joining the session today, and you may now have the floor.
Good morning, everyone. Thank you so much for joining this session. Please permit me to share my screen with you. Today we'll be talking about arbitration, trying to get an understanding of arbitration. Before we move ahead, I would like to know if you can show in the comment box, perhaps, how many of you know or have had experience with arbitration. If you have, just type yes in the Q&A box. Okay, I don't see anything in the Q&A box, so it means we are all fresh here to learn about arbitration. That means that we are going to take it very slow, and we will do the basics and make sure that we are covering everything. Now, let's start with what arbitration is. We will have that discussion in a number of ways or in a number of stages. Firstly, we will go through an introduction to arbitration so we all understand what arbitration is. We'll talk about the arbitration agreement. We will look at the arbitration tribunal. We'll look at the arbitration procedures and proceedings, the arbitral award, how an arbitral award is enforced, and how an arbitral award is set aside or annulled. So let's start. What is arbitration? Now, I'm sure most of us are aware of what litigation is. Litigation essentially is that when you have a problem, a dispute with someone, you file your case in court, a judge is appointed by the court, and the judge hears the case and makes a decision. Arbitration is very similar to litigation. Arbitration is private litigation. So instead of having to go to a court, which is a public forum, to have the dispute decided, you go to a private individual who will then hear the case and then make a decision. So arbitration essentially is a consensual process where the parties in dispute agree to refer that dispute to an independent third party for the party to decide the dispute. The arbitrator's decision is final and binding. From this definition, there are 5 things we can glean from what an arbitration is. Firstly, arbitration is a private dispute resolution mechanism. This means that it is a way in which we solve our disputes privately. Rather than going to the court, we do that privately. 2, arbitration is hinged on agreement. The parties must agree that they want to use arbitration to resolve their dispute. Without an agreement between the parties, you cannot have arbitration. The agreement between the parties must be that they want to submit the dispute to an independent third party. Then that independent third party renders a decision on the case, which is called an arbitral award. When you go to court, the judge hears the case and gives you a judgment. When you go for arbitration, the arbitrators, who the parties also choose to handle the dispute, will make a decision, which is called an arbitral award, after hearing the case and making a decision or on who wins or who loses, who is entitled to this and who is entitled to that. And that decision, importantly, is final and binding on parties. So now I know there's a bit of a confusion between what arbitration really is and what litigation really is. I've spoken to people who think that arbitration is just parties going to sit somewhere, having a conversation, having a third person try and hear the case and determine it, like a very friendly kind of thing. That isn't really what arbitration is. Arbitration, yes, is less formal than court. You won't have a judge wearing his wig and his gown. You will have an arbitrator dressed normally, probably in a suit and tie. In court, you will have lawyers there wearing their wig and gown, presenting their case. At arbitration, yes, lawyers are also there representing their parties. They are dressed normally. When you go to court, you see that the judge is seated at, on a higher level, looking down on everyone, listening to what everyone is saying. Usually at arbitration, you just have some desks. Yes, the arbitrators are separated from the parties, but the setting certainly is not as formal as the court. And most importantly, people think that arbitration does not take into account rules. Arbitration takes into account rules, except that the rules are rules that are agreed on by the parties. So let's take a quick look at arbitration versus court proceedings, because I think when we contrast arbitration and court proceedings, it will help us understand it better. Now, arbitration is private, whilst court proceedings are public. In arbitration, if you are not a party to the arbitration agreement, you cannot attend the arbitration proceedings or play a part in the arbitration, unless, of course, you are working with the panel. You are taking notes for the panel. You are a duly appointed official. But apart from that, unlike courts where the courtrooms are open and anyone at all can enter and sit there to listen to what the court is doing, arbitration proceedings are not like that. You will all recall recently that the Supreme Court broadcasted the election petition. Arbitration proceedings are not like that. it is a closed and private process, only belonging to those who are parties to their arbitration agreement. Now, litigation proceedings are in open court. Whatever is said, everyone can hear. Arbitration proceedings are behind closed doors. It's only the people who are involved and their lawyers and their witnesses who are allowed to participate. Now, an important thing about arbitration, which I think we all need to think about closely as an advantage, is that in arbitration, you are involved, the party is involved in selecting the person who is going to hear the arbitration case or determine the arbitration matter. Unlike court, when you file an action, you have no control over the judge who is appointed to sit and hear your case. All that you will be told is that your case is before Commercial Court 2 or Commercial Court 1. You go there, you see who the judge is, the judge deals with the case. Arbitration, there's an element of involvement because the parties have to select either the sole arbitrator or the arbitral tribunal. Sometimes the parties also agree for someone else to be the one appointing the arbitrator. So however it goes, there is some level of involvement in choosing who will decide the disputes. And that's very important because who is deciding the dispute, their background, their expertise, their knowledge will make a lot of difference in the quality of decision you get from them, or will determine whether they will even understand the type of disputes that is before them. Now, in arbitration, the parties agree on the rules that will apply to determine the dispute. The parties will agree on the rules. If you go to court, you have no involvement or a decision about what rules should apply to you. If you go to the High Court right now and you file a case, no matter who you are, the High Court civil procedure rules will be the rules that the judge will use to determine your case. The civil procedure rules will determine the timelines within which you are supposed to file, how the evidence is supposed to be presented. All of that will be in the rules. With arbitration, you get to choose or you get to participate in the choice of the rules. Now, there's something else about arbitration, which is confidentiality. In court proceedings, because it's public, there is no duty on the parties not to disclose what is going on in court. But with an arbitration proceeding, there is usually a duty of confidentiality, and especially where the parties sign, where the arbitrator will issue an order telling the party how the arbitration is going to go. There's usually a clause in that procedural order that says that the arbitration is confidential. So if you and I are having an arbitration, you are not allowed to go out and disclose what is happening in the arbitration or any information you get about me in the arbitration to third parties who are not involved. The same applies to the award. If we have an award, you are not allowed, the arbitrators are not allowed to share that award with parties other than the parties in the case. In courts, as soon as a judgment is given, anyone can apply for a copy of the judgment. You will even see it in newspaper reports where they have extracted parts of judgments and will put them in the newspaper report. However, in relation to arbitration, that is not the case. Publication of an arbitral award can only take place with the consent of the parties. Another very attractive thing about arbitration, if you compare it to court proceedings, are that enforcement is very wide, potentially wide in arbitration. If you go to court, enforcement of the judgment is restricted to the country in which the court is. A court's judgment from Ghana will be enforced in Ghana. An arbitration award has the possibility of being enforced in a number of jurisdictions, especially if the jurisdictions have all signed on to the New York Convention. The New York Convention allows arbitration awards that have been issued in a New York Convention state, that is a state or a country that has signed on to the New York Convention. That award can be taken to any other country that has also signed the New York Convention, and that award can be enforced in that country. So with arbitration awards, and especially with the New York Convention, it gives the arbitration award legs to travel all over the continent to be able to carry out enforcement. That is not the case with a judgment in the court. Now, you may wonder, why is it even important for SMEs? Why is it important for you to know about arbitration or to prefer arbitration? Now, there's several advantages for SMEs. Number one, SMEs are growing, they are developing. They don't have time to be embroiled in long litigation in court. The good thing about arbitration is that it's time efficient. You are able to move faster. You realize if you've had a case in court that by the time you file and then it is served on the other party and the other party also files, and then there are times before you can even appear before the judge, and then the judge will also look at his schedule and the schedule of lawyers before they can get dates. It's a very long and arduous process that you must go through. And after that, there's the right of appeal. If you have a case in the High Court, you can appeal to the Court of Appeal if you are not happy. And if you are not happy with the decision at the Court of Appeal, you can go to the Supreme Court. So very easily, one case, you can spend 4 to 5 years in court. With arbitration, a good thing about it is that the arbitration award is not subject to appeal. It is not subject to appeal. So it is binding on the parties, unless, of course, you have grounds to set aside the arbitration award or annul the arbitration award, which is where there has been serious procedural errors. There have been serious errors committed by the arbitral award that may give you grounds to set it aside. Apart from that, you have no other recourse. So in respect of being able to go through the motions quickly and have a binding award, arbitration is preferable to litigation because you get a decision and that resolves the issue. As I already said, choosing an arbitrator is an important part, an important advantage for SMEs. This is because SMEs have various specialized businesses that they are involved in. Imagine if you are a high-tech company making software and you are involved in some form of intellectual property dispute with another company. If you are able to choose an arbitrator, you will definitely keep in mind, one, the arbitrator's knowledge of the business that you are in or of the field that you are in, so that he can understand the nuances of the case. If you go to court, you will get a judge, but you have no control over the level of the judge's knowledge about the area of your business. All you can do is do your best to explain it, but there is nothing else you can do. With arbitration, by the choice of arbitrator you make, you are able to ensure that perhaps your position is understood better. That is another advantage. Another advantage, of course, is cost saving. If you're embroiled in litigation over 5 years, definitely you are spending a lot of money, not just time, but money in paying for legal fees, for filing applications, and all of that. If you are able to get an arbitration award, even in a year, you have saved 4 years of hassle. And as I said, the potential of enforcement across various countries is also high. And privacy, which a lot of people do not think about. Privacy is important, particularly for SMEs, because they are a growing business. They may not want their dirty linen to be washed out in public, or there may be some trade secrets. There may be certain things certain modules that they are using to make sure that they are able to get win an edge over their competition, or they are able to deliver certain results. And if you are involved in a litigation where potentially that kind of information will come out, you may not be comfortable going for litigation unless, of course, you are taking very, very serious steps to file applications for the court to grant certain orders so that certain information is not disclosed. But with arbitration, because of the inherent privacy you have in arbitration, that is protected. So that's an important thing for SMEs to think about when they are deciding whether to choose to do arbitration or they would like to do litigation. Now, if we talk about arbitration, there are various types of arbitration. So let's go through that quickly. As I've said already, arbitration is where two parties, two or more parties decide that instead of the disputes going to be heard in court, they will have an independent third party hear the dispute and issue a binding decision. Now we have something that we have two types of arbitration. We have institutional arbitration and ad hoc arbitration. Now, an institutional arbitration is an arbitration that is administered or supervised by an arbitral institution. So just as you have a case and you will go to the High Court complex and you will file the case there, and then they will appoint the judge, and then you will go into the High Court complex, look for the relevant court to appear before the court. And the court has a registrar, it has a whole mechanism that ensures that your case is handled properly and expeditiously by the arbitrator. When you come to institutional arbitration, there are arbitral institutions that can have general oversight or administer the arbitration. And therefore, you have that kind of body that is supervising the arbitration, and you are able to file your documents there. They're able to arrange for you to have the proper framework within which to conduct your arbitration. So, for example, we have institutions like the Ghana Arbitration Center, the Ghana ADR Hub. We have institutions like the London Court of International Arbitration. We have the Lagos Chamber of Commerce International Arbitration Center. They are all institutional arbitration providers. So if you look at the example we have here, I've put an example of an arbitration clause. You will see that in the arbitration clause, it says that any disputes arising out of or relating to this contract or the breach shall be resolved by final and binding arbitration administered by the Ghana ADR Hub. Immediately you see that it's being administered by an institution, you know it's an institutional arbitration. When we come to ad hoc arbitration, that is simply an arbitration that is not administered by an institution. And so we will have, for example, a simple arbitration clause that is saying that it is the dispute is being resolved in accordance with the ancestral rules. Usually the ancestral rules, when you see that, then you realize that it is an ad hoc arbitration. No institution has been provided to oversee the arbitration. We also have international and domestic arbitration. Now, for an international arbitration, it is when the parties to the arbitration agreement reside in different countries or are of different nationalities. So, for example, if I have a dispute with Abayomi, Abayomi is Nigerian, I am Ghanaian. In that case, when our disputes will be international in nature because we are of different nationalities. The arbitration transcends the national boundaries of Ghana or of Nigeria. He lives in Nigeria, in Lagos, I live in Accra. If we have a dispute, it will qualify as international. And of course, the more complex it is, the more easier that you are able to see how it transcends the national boundaries. There's domestic arbitration as well, which is where both parties are nationals of one state or country, or they all live in one country. So we have an example here. Sunset Company Limited, a business registered as a limited liability company in Ghana, enters into a contract with Mr. Osei, a financial consultant based in Ghana, to review the company's financial activities and provide professional advice. The consultancy contract signed between them contains an arbitration clause stating that any future disputes arising out of or in connection with the contract would be resolved by arbitration at the Ghana ADR hub under the Alternative Dispute Resolution Act. If you look at this scenario, you will see that both Sunset Company Limited and Mr. Osei are Ghanaian companies. Sorry, Sunset is a Ghanaian company. Mr. Osei is a Ghanaian. He's a Ghanaian national. So this would be a domestic arbitration. You will see that in the same arbitration clause, it provides for the Ghana AGR hub to be the particular institution that is charged with administering the arbitration. This makes it an institutional arbitration. Now, what is an arbitration agreement? An arbitration agreement is simply an agreement by two or more parties to submit all or certain disputes which have arisen between them in respect of a defined legal relationship, whether it is contractual or not. Now, from this definition, let's tease out the elements of an arbitration agreement. First of all, there must exist a legal relationship between the parties. You cannot have an arbitration agreement with someone you are not involved with in any you have no legal relationship with. So, for example, I will not be considered to have an arbitration agreement with a shop across the street if I have no business with that shop. But if I have some business to do with the shop, or I am their customer and they, for example, supply me some goods, then there is some form of legal relationship, some form of interaction. That is a formal relationship between us. That is the first thing that must exist. Then two, there has to be consent between the two parties that it is arbitration that they want to use to resolve their dispute. The third one is that the parties not only agree to arbitration, but they must agree that present and future disputes between them. It may be some disputes, it may be specific types of disputes, but the arbitration agreement will state whether it is all disputes or it is certain disputes. If you look at the definition here, you'll see that we say all or certain disputes. Now, another important element of an arbitration agreement is that there is an independent third party or private person to decide the dispute. Then the arbitration agreement would also indicate the scope of the disputes to be submitted to arbitration. Is it all disputes? Is it disputes in relation to breach of contract? Is it only disputes in relation to latent defects in a building? So the arbitration agreement will indicate the dispute, whether all or some, which should be referred. Now, another thing too that we must notice that the subject matter of the dispute must be arbitrable. And by saying that, we mean that the subject matter of the dispute must be capable of being resolved by arbitration. The subject matter of the dispute must be capable of being resolved by arbitration. Now, every country has the kind of disputes that can be resolved by arbitration and the kind of disputes that cannot be resolved by arbitration. So in Ghana, Section 1 of the ADR Act provides the instances where a particular type of case cannot be resolved by arbitration. Those matters are called non-arbitrable matters. So, for example, Section 1 says that if you have a dispute relating to an interpretation of the enforcement of the Constitution, you cannot go for arbitration. So if it is a constitutional right that you are trying to defend, even if the parties have an arbitration agreement between them, you cannot, that particular dispute will not be arbitrable. It is not capable of being resolved by arbitration. Again, matters relating to the enforcement of environmental issues, those matters cannot be resolved by arbitration. So you must also ensure that the kind of dispute that you have is capable of being subject to arbitration. The final thing is that the arbitration must be final. The award that the independent party issues must be final and binding. Now, as best practice, you need to, let's talk about what an arbitration clause is. An arbitration clause is simply an arbitration agreement that is situated within a contract. So if you have a contract with someone to supply you, let's say you have a contract for someone to supply you plastic for you to use in your business as an SME, you manufacture plastic chairs, and you have a supply agreement with another entity to supply you the plastic. In that agreement, if you put in an arbitration agreement, we call it an arbitration clause. It is a clause in the agreement indicating that this is what the parties are agreeing to be the preferred way in which they will resolve their disputes. Now, so I give an example here. If you say any disputes arising out of or in connection with this contract, which means that it is in a contract, including any question regarding its existence, validity, termination, shall be referred to and finally resolved by arbitration. The seat or place of arbitration shall be Accra, and the dispute shall be resolved in accordance with the Ghana ADR Hub rules. This is an arbitration clause, and we want to tease out the best practice of what should be in an arbitration clause. And this is very important because in my practice, usually when SMEs are entering into contracts, they will only take a copy of the contract, review it themselves, and then sign. In fact, they don't even look at the arbitration clause, which is at the very end, usually at the very end of the contract. They only look at the terms and conditions, the monies that they have to pay, the time that they have to pay. I agree, I agree, I agree. And they sign without looking at the arbitration clause. The arbitration clause is very important because when there is a dispute, at the time you are signing the contract, everything is sunshine and rainbows. So you don't think anything can go wrong, but any relationship can go sour, and therefore particular attention must be paid to the arbitration clause. And these are some of the things that you should look out for in the arbitration clause. That number one, does the arbitration agreement provide that the parties have agreed to go for arbitration if there's a dispute? Does the arbitration agreement indicate the scope of the disputes to be submitted to arbitration? Does it tell you whether all disputes or certain kinds of disputes or certain categories of disputes? If you look at the example we have here, you will see that we say the arbitration clause says that any disputes arising out of or in connection with this contract, including any question regarding the contract's existence, validity, or termination, shall be referred to arbitration. In this case, it means that every conceivable type of dispute that arises in connection with this contract will be subject to arbitration. Now, the third thing you want to look at is whether it includes an arbitral institution or it includes the rules that should apply to the arbitration. As we said, it is not automatic that if you have an arbitration clause, it will require you to be for the arbitration to be administered by an institution. No. So if what you want is to have a body administering the arbitration, you need to ensure that that is included in the contract. The seat of the arbitration is a very, very important part of an arbitration agreement. If the arbitration agreement does not indicate the seat, then when the matter goes ultimately to arbitration, that will be a subject that the parties will have to address the arbitral tribunal on for the arbitral tribunal to make its decision. Now, what is the seat of the arbitration? The seat of the arbitration is the state or the jurisdiction where the arbitration derives its legal presence. So if you look at this arbitration agreement, it says that the seat or place of arbitration shall be Accra. The seat is not the same as the venue. The venue is where the arbitration proceedings will be heard or the arbitration proceedings will take place. That's the physical venue. But the seat is a legal concept. It is the place where the arbitration derives its authority. So what does the seat do, or why is the seat important? So now if you look at this arbitration clause, it says that the seat is Accra. This means that the ADR Act, which is the Local Arbitration Act, will have some application to the arbitration. It also means that the court that is empowered to provide support for the arbitration, if that is required, will be the courts in Accra or in Ghana. So, for example, you can have an arbitration agreement that has the seat as Accra, but then the arbitration proceedings will be held in Lagos. The arbitration proceedings will be held in Lagos. If there are any questions as to the applicability of an arbitration act, it will not be the Arbitration Act in Lagos. It will be the Ghana Arbitration, the Ghana AGR Act that will apply. If the parties who are conducting their hearings in Lagos, for example, want a court to provide support to the arbitration proceedings, they will have to apply to the Ghanaian courts, which is the court at the seat of the arbitration. So a seat is very important. And if you have an arbitration clause, you want to make sure that the seat is familiar. If it's a seat, like, for example, if you're a Ghanaian company and the seat is Paris or Uruguay, you do not know what the laws, the particular arbitration laws in Uruguay are. You don't know how it will apply to you. You don't know how the case law has developed, and therefore you will be working in blind. It is always better to choose a seat that you are familiar with. And one thing I need to emphasize is that although we are given these tips, this work must be done by a lawyer for you. I know SMEs always hesitate to appoint lawyers, but there are certain things that you are unable to do. You will need someone with legal expertise to be able to critically look at the clause and determine whether the clause will work out in your favor. Now, the next thing that you must look out for is the method of appointment of the arbitrator. How are the arbitrators going to be appointed? Is it going to be both parties agreeing on one arbitrator, or is it going to be each party choosing their own arbitrator and the two arbitrators chosen then agree on a third person to be the chairman of the arbitration? You also have to consider, do you want to include certain qualifications that the arbitrator must meet? You may, for example, if you are a serious IT company that is entering into a software agreement with another IT company, you may, for example, want to indicate that the arbitrator should be someone who has a background in maybe IT or software development or whatever it is. But you need to make sure that you are not too specific in your arbitration agreement, because as it is, if you write that, for example, you want an arbitrator who has 16 years experience in software development, you may never get someone like that. So you need to keep an open mind. The language of the arbitration too helps if it says that if you are from two different countries, for example, a Ghanaian company and a Czechoslovakian company, if you have that, you know that there is a language barrier and you haven't already agreed on the language in which it should be conducted, that may become difficult. Now, the choice of law that should be applied by the arbitral tribunal is also an important consideration. If you're a company SME in Ghana and there's an arbitration clause that is saying that the substantive law of Ukraine should be applied in determining the dispute, you're putting yourself in hot water because you don't know what the law is. You don't know what the legal provisions are. And if, for example, it is a supply agreement where your suppliers are in Ukraine and you are receiving the goods in Ghana, wouldn't it be better that the laws in Ghana would apply? Do you know the sale of goods, the law relating to sale of goods in Ukraine? No, you don't. So you want to look out for that and see if as much as possible you can negotiate it so that it is more familiar to you, or at least to the lawyers who will represent you. Now, we've said that we have you can have an arbitration clause, and then you can have a submission agreement. So an arbitration clause is a clause within a contract that you want to submit future disputes arising to arbitration. With a submission clause, the dispute has already arisen. You did not have an arbitration agreement. The dispute has already arisen, and then you decide that, in fact, it would be better for us to go to arbitration. The fact that you didn't have an arbitration agreement in the first place does not mean that arbitration is closed to you. If the two parties can agree and put together an arbitration agreement after the dispute has arisen, then you can have an arbitration agreement after the fact. So a submission agreement is an agreement by parties to submit an existing dispute, that is a dispute that has already arisen between them, to arbitration. Now, the problem with submission agreements is that it happens when the dispute has already arisen, and it's very difficult for two disputing parties to see eye to eye. Things that ordinarily you would have agreed on, because you are in dispute and tensions have already risen, it's going to be difficult to now then belatedly agree on the terms of an arbitration clause. So the advice would be that as much as possible, try and have an arbitration clause at the very beginning in your contract, rather than thinking that, well, if we actually have a dispute, we can at that stage then agree to go to arbitration. You may never get that opportunity, or you may never be able to reach that understanding. So I give an example, for example, of a submission agreement, because this is something that I see a lot in SMEs. Initially, they never adverted their minds to arbitration, and then they realize the benefits of arbitration and they want to go for that. So in this example, we say that they are parties to a fintech contract who have a dispute resolution clause that allows them to go to court. Now, as a dispute subsequently arises relating to a defect in a novel software used on an electronic platform on which the fintech product will operate. The dispute is of a very technical nature, involving in-depth understanding of algorithms relating to the software in question, and must be resolved within 3 months to enable the purchasing party launch its novel fintech product. Now, the parties are concerned about the time it may take to resolve the issue in court, since a delay in the launch of the fintech product would greatly compound any damages claim and would no longer make the product competitive on the market. So the parties also worry that because the kind of dispute is very niche, it's in a very technical area relating to a novel software, which means it's a new software that does not exist. It has now come into existence, being operated on an electronic platform. They feel that they need a specialist who can understand the dispute properly to determine it. The parties therefore agree on a submission agreement after the dispute arises. So in that submission agreement, then the parties will specifically provide for an algorithm specialist, for instance, with 6 years knowledge or experience or whatever, to be able to resolve the dispute. At least with that, they are assured that the person making the decision will actually understand the case and be able to give a just decision. Now let's talk about the arbitral tribunal, which is very central to arbitration. As we've already said, an arbitral tribunal or an arbitrator is a private individual. This person is not a judge, it's a private individual who is appointed by the parties to resolve the dispute. Usually you have one arbitrator who sits as a sole arbitrator, or 3 arbitrators. Now, the competence of the arbitral tribunal is very important, because the arbitral tribunal is given certain powers. It's given certain powers, and the power is for the arbitral tribunal to rule on its own jurisdiction. So an arbitral tribunal can decide whether, for example, the dispute that has been brought before it comes under the arbitration agreement. It can decide whether the contract in which the arbitration agreement is valid. It can even decide if the arbitration agreement based on which he himself was appointed is a valid arbitration agreement. So the arbitrator has a lot of powers. Now, I just want to give an example to highlight what we mean by the competence of the arbitral tribunal to rule on its own jurisdiction. Thank you for the questions. We will try and address them as we go along, but I have specific time at the end dedicated for us looking at the answers to the questions. So this is the example. A bank has purchased 2 plots of prime land to build their head office. They engage a reputable construction firm to construct an 8th-floor office complex for use as their head office. The construction contract signed by the parties includes a dispute resolution clause where they are first supposed to attempt settlement for 30 days. And then if that settlement does not work, then the CEO and the project manager of the 2 companies will then engage in mediation for another 30 days. The mediation must be facilitated by an engineer appointed by the Ghana Institute of Engineers. If the parties are unable to resolve the dispute after 10 days, then the dispute has to be referred to arbitration. The dispute arises between the parties in relation to the tiling of the 2nd and 3rd floors of the building. The bank refers the dispute to arbitration, and the ADR hub appoints a sole arbitrator. The contractor challenges the jurisdiction of the tribunal. So the factual scenario really is that there is an 8th-floor complex. And under the arbitration agreement, certain types of disputes are supposed to be resolved by arbitration. If you look here, you will see that the first ground, sorry, please, let's go over the facts again. It's an 8th-floor story complex that they are using as their head office. The construction contract includes an arbitration clause. And in the construction contract, it doesn't say that all disputes should be sent to arbitration. It says that disputes relating to, disputes relating to latent defects. So if the dispute does not relate to latent defects, then the arbitration clause does not cover it. And then they are supposed to refer it to the Ghana ADR hub for the ADR hub to appoint a sole arbitrator. Now, a dispute actually arises between the parties relating to the tiling of the 2nd and 3rd floors of the building. So it's not a latent defect. The bank refers the dispute to arbitration and proceeds itself to appoint a sole arbitrator. Now, the other party, the contractor, challenges the jurisdiction of the arbitral tribunal on 2 grounds. First, that the dispute does not relate to latent defects, and therefore it is not within the scope of the arbitration agreement. And second, that the arbitrator was not appointed by the Ghana ADR hub and therefore cannot hear the case. So in this case, we are saying that the arbitrator himself, who is even sitting on the matter, we are saying was not even properly appointed and he cannot hear the case. Now, by virtue of the competence of the arbitral tribunal, this challenge to the arbitral tribunal's jurisdiction will be heard by the arbitrator himself. So the arbitrator will have to decide whether the dispute indeed falls within the arbitration agreement and whether the appointed arbitrator, which is himself, can preside over the dispute. So after the arbitrator makes that decision, if the parties want or if the parties are unhappy, they can challenge this decision. But the thing is that, firstly, it must go to the arbitrator himself to decide. You know that unlike courts, when sometimes cases come before a judge, the judge will, because it involves the judge himself, he will not be able to comment or decide on that himself. But with an arbitration tribunal, even questions relating to their own powers, they have power to rule on such matters. Now, let's go to arbitration procedure and proceedings. When we are talking about arbitration procedure, there are a number of frameworks within which the arbitration is conducted. Firstly, there's the substantive law of the arbitration, which is the law that the arbitrator must apply to decide the merits of the dispute. If you go to court and you have a case and your contract is governed by Ghanaian law, it is Ghanaian law that the courts will use to decide your case. If you have a contract that says that Ghanaian law must be decided and there's a dispute in Germany, that dispute, although it is happening in a different forum, is still governed by Ghanaian law, and it is Ghanaian law that must be applied to deciding the case. So we have the substantive law of the arbitration, which is the law that the arbitrators will apply to decide the case. And then we have the procedural rules of the arbitration, which also is the set of rules that the tribunal will use to determine how the arbitration proceedings are organized. So, for example, the procedural rules will, such as the Ghana ADR hub rules or the rules of the Ghana Arbitration Center or the ancestral rules or the London Court of International Arbitration rules. These are all rules that will set out what the timelines are for the parties to file. You have 10 days after you are served with the claimant's case to file your response. That is determined by the procedural rules. And the procedural rules will also determine the procedure for the hearing of the arbitration. Now, the arbitration is not insular. There is still some kind of relationship between arbitration and the courts. So, for example, if you have an arbitration and you need the courts to issue an order to support the arbitration proceedings, the Ghana AGR Act allows the courts to intervene in specific circumstances to support arbitration. So, for example, if you have an arbitration agreement with your supplier, for example, and based on that arbitration agreement, you have commenced arbitration proceedings, but the issue that you are fighting over, for example, the goods that they supply to you that you are fighting over, that you sent back to them and rejected, they may still be in your possession or they may still be in their possession, because it is an important subject matter of the dispute. The courts on application by a party. That means the party will go and file something in court and ask the court, please come and support this arbitration proceedings. We are fighting over this drilling machine that they supplied to me. We need the court to preserve this drilling machine so that none of the parties interfere with the drilling machine whilst the dispute is being heard. That is something that a court can give to you. So can you imagine, for example, someone having had received goods, maybe a drilling machine says that the goods does not conform to the specifications, or the good, there's a defect in the goods. The other party can ask the court to preserve it so that it's not like it's still in the person's property and the person's possession and the person is using it, or the person, it's in the person's possession and the person can tamper with it to beef up their case. That is something that you can go to the court to ask the court to give you. Now we continue with our discussion on the arbitration procedure and proceedings, and we talk about how you go through the various stages of arbitration. Arbitration starts first by a party who is unhappy with something, filing a notice or sharing a notice indicating that they are commencing arbitration. If you were doing a court process, you would file a writ and a statement of case, a writ and a statement of claim. In the writ, you will put in the written statement of claim, you will tell your side of the story and ask the court to grant you certain orders against the other person. In much the same way, if you want to commence arbitration proceedings, you must put down the nature of your dispute in a document and then indicate the reliefs or the things that you are seeking from the arbitration in that same document. And that document is served on the other party. That is how the arbitration is commenced. So arbitration starts with one party filing a notice of commencement of the arbitration. Once that is done, the arbitral tribunal is composed. So you have the initiating document process that starts the arbitration process. Then the arbitral tribunal is composed. As I said before, you can have one arbitrator who is sitting as a sole arbitrator, or you have 3 arbitrators usually who will be appointed, one by each party and the third by the 2 appointed arbitrators. Once the arbitral tribunal is composed, then looking at the procedural rules, timelines are set for each party to file their statement of claim or statement of defense. That is the documents that the arbitral tribunal will be using to evaluate the various cases or grievances that have been brought before them and the responses to those grievances by the other side. Then you have a preliminary meeting where they will meet, the parties will meet with the arbitrator, and the arbitrator will set down the guidelines for the conduct of the arbitration. At the preliminary meeting, they may indicate the dates where they will have the hearing, the time where they will have the hearing, the venue where the hearings will be held. All these matters are agreed at the preliminary hearing. Parties will indicate which witnesses they will be calling, all of that. Discovery, usually, as the word suggests, it's finding out documents that are in the possession of the other party, which are required in the case. Usually with arbitration, when parties file their pleadings, they attach copies of the supporting documentation, or when they file their witness statements, which is the written evidence that they are going to give at the arbitration hearing, they usually attach all documents. But sometimes some parties choose to hide certain documents or not disclose certain documents, and provision is made for a party to ask the other party to discover, to bring out those documentation for the arbitral tribunal to use and for the other party to use if it is beneficial to them. Now, when we come to the hearing, it is not all the time that you have a physical meeting or a hearing. You can have an arbitration conducted on documents alone. You can have an arbitration conducted on documents alone in certain cases. So, for example, if two parties are disputing about the interpretation of a contract, for example, two parties have a supply contract and they have agreed that you pay a first tranche of money once the agreement is signed. You pay a second tranche of money once the goods are supplied to you. And then you pay a third tranche of money after a number of days. If there's some dispute as to whether the agreement said that this particular time is the time that the payment should be made, that, for example, may not need a full hearing. So let me give you an example, a typical example. If you have a supplier who is supplying you goods and they are supposed to first of all supply you, first of all, you sign the contract, you pay some money. They supply you the goods, you pay some money. And then at the very last stage, maybe after a number of days, you pay the last tranche. Now you have ordered 10 things. They have supplied 9. You haven't received the 10th thing. Are you still required to pay the money when you haven't received the 10th thing? That can easily be a subject of dispute. And if it is merely a matter of interpreting the contract to say that, well, in this case, if you haven't received the 10th thing, then your obligation to pay has not yet arisen. You don't even need a full hearing for that. So the the arbitrator can look at the documents that are before him, read the contract, and then decide when that obligation arises, the obligation to pay. But you have circumstances where there are a lot of factual matters that are disputed between the parties. One party is saying this happened, the other party says no, the other thing happened. When there are a lot of factual misunderstandings, it's important for the court to hear both parties, to hear what their witnesses have to say, and then decide the dispute. And in that case, you have an oral hearing. And an oral hearing doesn't necessarily have to be physical. As you all know, with the COVID-19 era, we are having proceedings virtually. So virtual hearings are also part of the hearing stage. After all this happens and the matter has been heard, then they issue an arbitral award. The arbitral award, as we've already said, is binding on the parties. You only have very few, then you have only very few circumstances where you can challenge the arbitral award. But if the arbitral award is not challenged, then you go to enforcement, which is trying to give power or strength or derive the benefits that the arbitration agreement has given you. And that may include, for example, if the arbitral tribunal has ordered that the other party should pay money to you and the other party has not paid, you can actually enforce the award against them, attach their assets so that you can sell and get the money you have been awarded. Let's move on to talk about the arbitral award. These are pointers about the arbitral award. It has to be in writing, final and binding on the parties. It must be reasoned. So it has to state the reasons upon which the award is based. It must be signed by the arbitrators. It is only valid where it has been signed. If one of the arbitrators in a panel of 3 arbitrators doesn't sign, it has to state the reason why one person has not signed. The award must indicate the date on which the award was made. It must state the place where the award was made, which is the seat of the arbitration. So in the example that I gave, that I have a dispute with Abayomi, for example, and we are hearing the case in Lagos, but the seat of the arbitration as provided in the arbitration agreement is Accra. When the award is being delivered, the indication in the award will be that it is an award delivered in Accra, not the physical location where the hearings were held. And once it has been signed, dated, and the seat of arbitration or place of the arbitration indicated, then it has to be communicated to the parties. And as we've said already, the arbitrators are not allowed to make it public to others. They can only communicate their decision to the parties unless the parties have given their consent. Now, there are very limited circumstances where you can set aside an award. So I would say that when you are going in, have it in your mind that you are going to be bound by the arbitration, by the award, because it's only in few circumstances where the court will say that, in fact, this award is not a valid award or is not good enough and should be set aside. And in Ghana, for example, if you have a foreign arbitral award, that is an award that is seated not in Ghana, but somewhere else, the court will look at whether the award has been set aside at the seat. The court will consider whether the person whom the losing party was given sufficient notice of the arbitration proceedings to enable them present their case. They will look at whether the award deals with issues that were not submitted to arbitration. They will look at whether there was some incapacity. One of the parties had an incapacity, which would make the arbitral award unenforceable, or will mean that it is unfair. Usually, when the court is looking at setting aside, they are looking at some form of procedural impropriety that happened during the arbitration. One party was not given an opportunity to be heard. One party was not given sufficient time to present their case. The arbitral tribunal was not composed in accordance with the way that the parties had agreed. The subject matter of the arbitration is not arbitrable. It is not that the kind of dispute is not one that can be settled by arbitration. These are the only grounds, and perhaps yes, these are the only grounds that if you have a foreign if you have an arbitral award, it can be set aside. The same applies to domestic arbitration. There are a few, very few instances where the court will set aside an award. These have all been stated here. Now, when we come to enforcement of an arbitration award, remember, an arbitration award is not a judgment of the court. It is only a court that has that compelling mechanism behind it to be able to enforce an award. An arbitral tribunal cannot enforce an award because they are normal citizens, they are private citizens. So if you need a court to compel a party to satisfy their obligations under an arbitral award, then you would need to come to the court and ask for leave for the arbitral award to be enforced. So in Ghana, for example, if you have an arbitral award, and arbitral awards are enforced as judgments of the court. So technically, they are converted to become judgments of the court and then enforced as any other judgment of the court is enforced. So first of all, you have to apply for leave from the court to enforce the award as a judgment. The losing side, of course, will have the opportunity to respond to the application that you filed. The court will hear the application and then grant leave to enforce the judgment, the award, if it feels that there are just circumstances. Now, when it comes to enforcement of the award, the court is not now looking at the merits of the arbitrator's award. The court is not considering whether the arbitrator's reasoning is valid or not, or whether the arbitrator's finding that one person did this or the other person did that is valid. No, the court is not an appellate court that is reviewing the decision of the arbitral tribunal. It is simply ensuring that the award complies with certain requirements, and we have talked about some of them. Did the parties get enough notice about the proceedings? Were the parties given enough, were the parties heard, given time to present their case? Was there any form of bias on the part of the arbitrator? Was the arbitrator, for example, someone who had an interest in the matter but did not disclose this interest? These are the few circumstances where the court will not enforce the award, will not grant leave for the award to be enforced. But once the court grants leave, then the award essentially becomes a judgment of the court, and just like any other judgment of the court procedures are used to enforce. So, for example, if the arbitral award said that you are entitled to $5 million and the other side has not paid you the $5 million, if you come to the Ghanaian courts and you are given leave to enforce the award, you will file processes at the court's registry, and the bailiffs of the court will go and attach properties belonging to the person who is supposed to pay the 5 million under the arbitral award. And the whole court process works in such a way that you go through processes where these goods will then be sold for the sums of money you must be paid to be satisfied. So it's the normal court procedure that is used to actually realize the arbitration award. Now, there are some key points for SMEs. Why, we've already told you the advantages of choosing arbitration over litigation. But if you are choosing arbitration, you need to think about these points. Number one, you should have the arbitration clause in your contract. Have it on straight ahead. Don't wait. That will help you avoid protracted litigation. The arbitration clause should be properly drafted. And here I say, engage a lawyer. Don't try to do it on your own. You may not have all the necessary skills. Take care in who you choose to be the arbitrator in your matter. You need to think about the person's background, the person's knowledge, because a good arbitrator is more likely to reach a fair decision. You also need to ensure that you are putting your best foot forward in the arbitration, because as we said, arbitration is final and binding. You don't have any way of appealing unless there are limited circumstances where you can set aside the award. There isn't much you can do. And then also use arbitration with other forms of AGR to save costs. Remember, litigation is expensive, and being in court for a long time is not only going to cost you money, but it's also going to prevent your business from growing, because your attention is divided, and your expenditure and manpower is also going into trying to ensure that that case is being won. So these are the things that I would recommend for you to take account of if you decide to use arbitration to settle your dispute. Now, I'll invite questions, and I've seen that there are a few questions already. Yao Sompa says that if arbitration is based on consent, how can it be compelled by statute? Example, Act 913 Ghana. Does the insistence of arbitration as the means of redress by statute not oust the jurisdiction of the court's jurisdiction without and against the elections parties sought to have? Now, I have to say that there is a difference between statutory arbitration and arbitration as we are talking about. Statutory arbitration is not essentially the kind of arbitration that we are talking about. The arbitration is the chosen by the parties that this is how they want their disputes to be resolved. There are certain industries and certain areas where the statute says that you have to go for arbitration. Sometimes that has been interpreted to mean that once you submit to that industry and you know that this is the law regulating that industry, then impliedly you are also saying that you are agreeing to the dispute resolution mechanism that that particular industry has provided. I realize that our time is fast spent. Let me move to the next question. Please, can any professional be trained to be an arbitrator, or is it limited to the legal profession? No, anyone can be an arbitrator. It helps if you have legal knowledge, but certainly if you have a panel of 3 arbitrators, parties are looking at having a mix of different skill sets in the panel. They may want someone with legal knowledge, they may and then someone with some expert knowledge as well. So no, arbitrators are not only lawyers. We have accountants who are arbitrators. We have energy experts who sit as arbitrators. We have software experts who sit as arbitrators. So no, you do not need to be in the legal profession. But what then means is that the parties will definitely then be looking at having someone who has some knowledge of law and the arbitration procedures to augment your skills. I think that is the end of the questions we have. I don't know if anyone has anything else. Otherwise, I see that my time, I have 1 minute left. I really try to stay within the time because I don't want Abayomi to chase me off.
Oh, no. Right. I'm not sure if there's any other question, at least not in the Q&A box.